Admissible evidence, in a court of law, is any testimonial, documentary, or tangible evidence that may be introduced to a fact-finder, usually a judge or jury, to establish or to bolster a point put forth by a party to the proceeding. For evidence to be admissible, it must be relevant, without being unfairly prejudicial, and it must have some indicia of reliability. The general rule in evidence is that all relevant evidence is admissible and all irrelevant evidence is inadmissible. For evidence to be admissible, it must tend to prove or disprove some fact at issue in the proceeding. However, if the utility of this evidence is outweighed by its tendency to cause the fact finder to disapprove of the party it is introduced against for some unrelated reason, it is not admissible. Furthermore, certain public policy considerations bar the admission of otherwise relevant evidence. For evidence to be admissible enough to be admitted, the party proffering the evidence must be able to show that the source, if the evidence makes it so. If evidence is in the form of witness testimony, the party that introduces the evidence must lay the groundwork for the witness's credibility and knowledge. Hearsay is generally barred for its lack of reliability. If the evidence is documentary, the party proffering the evidence must be able to show that it is authentic, and must be able to demonstrate the chain of custody from the original author to the present holder. The trial judge performs a gatekeeping role in excluding unreliable testimony. The United States Supreme Court first addressed the reliability requirement for experts in the landmark case Albert v. Merrill Dow Pharmaceuticals, Incorporated 509 U.S. 579, 1993. The court laid out four non-exclusive factors that trial courts may consider when evaluating scientific expert reliability. 1. Whether scientific evidence has been tested and the methodology with which it has been tested. 2. Whether the evidence has been subjected to peer review or publication. 3. Whether a potential rate of error is known. And 4. Whether the evidence is generally accepted in the scientific community. At 592-94. Kumho Tire Company, Limited v. Carmichael later extended the Daubert analysis to include all expert testimony. 526 U.S. 137, 1999. It bears an effect on the verdict of the court.
There are several different types of evidence. These are just a few: facts, statistics, quotes, examples. All of the types of evidence should directly and clearly relate to the reason that they are supporting, and ultimately, the goal is that they help prove the claim in which they are supporting. So let's look again at this same paragraph we've been looking at for the last couple activities and this learning target and the previous. So using facts is a powerful means of convincing. So facts are often need numbers to back them up. So here we have a fact. For example, some year-round schools have frequent breaks. Okay, so we know this, and that's a fact. But to explain that a little bit further, there's more evidence, and there's statistics. There's some numbers to go with it. So they have a 60-15 calendar where they're in school for 60 days and then out of school for 15 days. So statistics or numbers usually come with the facts they are trying to help prove, to explain, or to elaborate. Sometimes evidence comes with quote. Using quotes from leading experts or authorities in their fields will support your position. So Samantha King, no one knows who Samantha King is, but if you include who she is, a noted forensic specialist, stated that DNA evidence is usually indisputable. So a forensic specialist is probably going to know a lot about DNA evidence. So if she says this, we can trust this piece of evidence as relevant if it relates to our reason and ultimately goes to support our claim. Personal experience is another really great piece of evidence. You have to be careful that personal experience isn't just a person that you know, but it's actually a person with personal experience related to the claim in which you are trying to prove. So using examples or anecdotes, which are short little stories from your own experience, can enhance your meaning and also engage the reader. Personal examples make your ideas concrete. These real-life examples allow a reader to relate to the issues personally. For example, here's an example of a personal experience. After living in Iceland for a decade, I can honestly say that the people are kind and warm. Now, this person has a personal experience of living in Iceland, so they can honestly say that what the people are like because they lived there. Now, if you have your best friend who just loves Iceland so much but has never lived there, your personal experience with your best friend is not going to be relevant evidence. Your best friend might know a lot about Iceland because she read about it on Wikipedia, but that doesn't make her evidence relevant. What would make a personal experience relevant is if they have personally experienced something relating to your reason and ultimately relating to your claim. So no matter what kind of evidence is used, all evidence must help support the reasons which prove the claim. So relevant evidence relates directly to the reasons it is helping to support and the claim it is trying to prove. Always remember, a claim is proven by clear reasons that are supported by relevant evidence.
Students often receive research assignments requiring the use of credible sources. But what does it mean for a source to be credible? Why is it important to use these sources? And how can you tell if a source is credible? When we describe a source as credible, we're basically saying that the information is high quality and trustworthy. Essentially, that we can believe what the source is telling us. When you use high-quality sources to back up your points, you demonstrate your own credibility as a writer, thereby contributing to the overall effectiveness of your argument. The best quality research builds on other high-quality research. This is true of both your own work and the work of professional researchers. There are several factors that contribute to a source's credibility. Among them are the author's level of expertise, her point of view, and the source's publication date. The author's level of expertise on the topic he or she is writing about could take the form of an advanced degree or other extensive experience in the field. A credible source often provides information about the author's credentials. Sometimes, however, the author's credentials may not be listed, and the publication itself can be the marker of quality. This is often true for some non-scholarly publications like well-respected newspapers and magazines, where the article's content is critically examined as part of the publication process. Another important component of a source's credibility is its point of view, in particular its potential bias. Bias is an inaccurate or unfair presentation of information. In some cases, bias is intentional. A group with its own agenda may sponsor research or information, and the sponsorship may influence the results. Bias can also be unintentional. A writer's perspective may prevent him or her from being able to see all sides of an issue. Sometimes you need unbiased facts to support your point. But other times you might want people's opinions, and that's okay, as long as you acknowledge the source's perspective in your own work. While bias can be difficult to detect, be aware that it can exist in any kind of source, including things you find through the library. In the academic publishing world, books and articles go through a rigorous editorial process, in which an editor or group of scholars evaluate the work's quality. When it comes to journal articles, this process is called peer review. Peer review articles are considered high quality because the review process helps to filter out sources that are written by unqualified or biased authors. Finally, with any source, consider when it was published or last updated. Even something that was once high quality can now be out of date and unsuitable for some purposes. If I needed current statistics on the average cost of college in the United States, a source published in the 1990s would be out of date. However, if I was looking at the increase in college tuition over the last few decades, a source from the 1990s might fit my purposes. Of course, not every credible source is appropriate for your research. Be sure to evaluate not only a source's trustworthiness, but also its appropriateness for your argument. For help finding credible sources or determining whether a source you've found is credible, ask a librarian.
All right, hello, and welcome to this evidence video capsule. And this is going to be a fun little capsule, and I do say little. And the reason it's going to be short is because even 10 years ago, this would have been a very complex capsule with a lot of issues surrounding competence and compellability. Luckily for all of us, these rules have been radically streamlined in the modern era, and the rules about witness competence are virtually irrelevant. Compellability still plays a factor, but nowadays understanding the rules is as simple as 1, 2, 3, so let's just jump right into it. So in our system of justice in Canada, we believe first and foremost that it is witnesses who should provide the bulk of the evidence. We certainly try to narrow the nature of disputes through admissions and sometimes use judicial notice to prove obvious things. And as I will show in another capsule, we obviously admit lots of documents and real evidence to prove things. But first and foremost, we want witnesses to come forward and testify about what they know. I like to say that witnesses are the gasoline of the trial engine. Without them, we can't really have an effective judicial system. So we need to be able to call them to volunteer to give evidence or force them to give evidence. And really, that's what competence and compellability is all about. And that's as good a place as any to start. A witness is competent if they are eligible to testify. A witness is compellable if they can be forced to testify. And both of these doctrines need to be understood within the context of a third. Sometimes you will have a witness who is competent and compellable, but holds nothing but privileged information. Well, think about it this way. Let's assume that the only relevant information they know is privileged. Can they testify? The answer is no. Are they competent? Sure, they're competent. They are eligible to testify because competence looks at their status as a witness. Can they be compelled to testify? Absolutely. They're in front of the courtroom. They can be forced to testify. But they have no material evidence to offer because everything they know is covered by privilege. So in other words, there are different reasons why a witness may not be able to give evidence or may not be able to be forced to give evidence. We don't call them all the same thing. For the purpose of this capsule, a witness is incompetent if they do not have the necessary prerequisites or status to testify. They are not compellable if they have that status, but for some policy reason, they cannot be forced to testify. And frankly, they are both competent and compellable, but have no relevant evidence to offer if everything they know is covered by privilege or immunity. And by the way, on this last point, one final matter. Obviously, if they have some things they can testify and some things they can't testify about, they're only allowed to resist matters that are covered by the privilege or immunity. So a witness who's holding such a privilege or immunity is very different from a witness who is not competent or compellable. Now, I said that in the old days, the rules of competence and compellability were very, very important, and the reason can be summed up in a nutshell. Competence used to be used as a way of screening out unreliable evidence. So, for example, at common law, accused persons were incompetent to testify, even on their own behalf. They couldn't testify for themselves. And the reason was because the common law said, well, they're interested parties. And interested parties are not likely to give reliable evidence, so we will kick them out. Those rules are gone, all of them. The competence rules, I won't even bore you with the details, have all been wiped away. We no longer treat unreliability as a reason to exclude a witness. We make it a question of weight. If you don't want to believe his evidence because he has an interest, that's fine. That is something for the jury or trier of fact to consider in weighing the witness's evidence. Johnny still has an important interest to protect, and that interest is the right against self-incrimination. You can't force Johnny to testify, and that's why today we respect that right in a more limited way. You cannot be compelled to testify against yourself, but you can volunteer to testify if you wish to do so. And that sort of shows you the difference between a competent witness, Johnny, and a non-compellable witness, also Johnny. He is non-compellable on behalf of the prosecution. So these days, competence really asks whether a witness has basic testimonial capacities, and that's really all it is. At common law, every witness had to have a very minimal capacity to do these four things. Okay? And I can tell you that under statutory law today, these requirements have been reduced even further. Nowadays, we respect these four things, but a lot less than we used to. The real issue arises when we're talking about young children who might not be able to perform these four tasks and mentally disabled adults. Those are really the only two categories of witness for which we need to worry about competence anymore. And today, even those requirements are very rarely contested and not that hard to meet because the basic rule is we want these witnesses to testify if they can, and if they can, will let any weaknesses in their abilities to do these things go to weight. Remember, in the old days, it was the reverse. All the weaknesses went to admissibility. They would say to kids, well, you're not good enough as a witness to meet the minimum, so we're going to kick you out. Today, the entire philosophy is different. Bring the witnesses in and let's hear what they have to say. Test their evidence as a matter of weight. And the governing statutory law makes that clear. We presume that young people have the capacity to testify. We don't even let them take an oath anymore because there used to be a lot of kerfuffle about, well, they didn't understand what an oath was, so we're not going to let them testify. We also make it clear that when they promise to testify, we will let them do it as if they are taking it under oath. And the only real criteria is to show that they can understand and respond to questions. And again, all of this has been done to make it easier to bring witnesses in to the judicial process. And the law is not much different for witnesses who have problems with mental capacity. And I should stress, if you did have witnesses who had a really severe mental disability, a severe form of dementia or a severe form of progressive intellectual disability, you could definitely have them excluded as a witness, though frankly this doesn't arise very often because it's got to be pretty extreme circumstances to want to call one of those witnesses. Effectively, they'd be the victim of an offense of some sort. But again, all of this is designed to make it simple. We want to be able to show, are you able to communicate the evidence? If you can't swear an oath because you don't understand what an oath is, no problem. Just promise to tell the truth. Again, all of this designed is really to get around the competence inquiry. We don't want this to screen out witnesses unless they are so problematic that we just have no choice. We can't put them before the judicial process. And that's really all there is to say about competence. The more interesting questions these days, and even these are pretty limited, have to do with compellability. And essentially, you can really boil it down to about 4 categories of witness for whom compellability can be a problem. I already told you about the accused. That's an absolute rule. You cannot compel the accused to testify against themselves in their own trial. The other one is a judge. You're not allowed to call the judge to testify about any aspect of their judicial capacity. I should point out that a judge is the same person as anybody else, just a person, and if a judge witnesses a bank robbery on their way to work one day, no problem. Call them as a witness. But judges cannot be called to explain some aspect of their judicial reasoning. We don't want that to happen. There's a bad policy behind that, including the idea that judicial independence needs to be preserved. So we don't allow it to happen. Ministers and politicians, very complex area that I'm not going to get into too much detail here. I may do a supplemental capsule on this down the road. But essentially, ministers and politicians are not immune from being called as witnesses either. However, they have a special form of immunity called parliamentary privilege that allows them to delay testifying. Okay? And I should say that in practice, courts are very skeptical about the ability to call ministers and politicians simply because they're wary of, the individual litigants trying to embarrass politicians and ministers. So that doesn't mean they won't be called, but the courts will look very carefully at whether or not it's necessary to call those witnesses. But again, the doctrine of parliamentary privilege is a form of immunity, and if the minister or politician fits into that parliamentary privilege, they can resist giving evidence. And the last one is the opposing lawyer in a case. Now again, lawyers are not immune from being called as witnesses either. But as you can imagine, calling an opposing lawyer to testify is a real tricky business because essentially the courts don't like having lawyers act as witnesses at the same time. It puts them in a very bad position where they have to judge the credibility of the witness lawyer, and the lawyer is also, the agent for the party. So the courts really like to resist that. So the way in which they resist that is they don't let lawyers get called as witnesses. And essentially what happens is, if you want to call an opposing lawyer as a witness, you've got to show that it's absolutely essential. And if you can't do that, they won't allow you to call the witness. But if you can do that, they'll usually strike that lawyer as the lawyer of record because now that lawyer is a witness. This is a little bit of a complicated area of law, but I can tell you that that's the basics of it. If a lawyer is going to be a witness on any type of controversial matter, they will no longer be allowed to represent the party in question. And if you can't show that it's really necessary to have them testify, you cannot compel them to testify as you would an ordinary witness. So keep in mind, Problems of compellability are interesting ones, and as you can see, what binds them together is strong policy reasons why you should not be able to call this category of witness: judge, accused, minister, opposing lawyer. And that's all we're left with today in considering a huge slate of old rules that used to deal with competence and compellability. We're left with competence rules dealing with some very extreme types of witness, very young children, very mentally disabled adults, and a few problems of compellability. That's really all you need to know about basic questions involving witnesses. I hope this was of interest to you. Have a great day.
Thanks for watching this Evidence Law Capsule. To learn more about this topic, check out Professor Sankoff's book, Mewett and Sankoff on Witnesses, published by Thompson Carswell. A new, expanded edition of this book, focusing on the law of evidence and witnesses, is in progress.
Imagine for a moment a world in which police still officially needed warrants in order to search people's houses, but they knew that even if they went into a house without obtaining a warrant, the information that they obtained was still going to be able to be put before the court. What would there be to stop police from committing break and entries constantly in order to obtain important evidence in relation to serious cases? The answer is pretty much nothing. The courts see it as important to maintain the integrity of the justice system to require that evidence that's put before the court must be obtained lawfully. Bunning and Cross is a great example. This is a case where a motorist was pulled over for driving erratically, and the police officer pulled this motorist out of the car, took one look at him and said, "You're drunk, mate." Took him off to the equivalent back in the day of what we would now call a booze bus, and applied the second level of testing, the more accurate level of testing, to determine this driver's level of blood alcohol. And the driver, of course, came up with an unlawful amount of blood alcohol. What they argued in court, however, was that the statutory requirements for blood testing at that time required that the initial screening test be administered on the side of the road. So in other words, the rules required that the driver would have to blow in the bag on the side of the road, and if that test showed that they were under the influence of alcohol, then they should be taken away for a more accurate test. So the argument was made that in this case, the second test was unlawful because the driver never had the opportunity to provide a roadside breath sample. Now, I get the sense when I read the case that the High Court wasn't particularly happy with letting this driver off, that the High Court would rather have convicted this driver for drunk driving. But at the end of the day, the High Court said it's important that police follow their own procedures. It's important that where there are procedures set up by the Parliament saying to police, this is how you must gather evidence, well, the police ought not to set that parliamentary decision to one side. If there's a process there, police ought to use it. If they don't use it, and the evidence is obtained unlawfully, the court's not going to receive it. So those are the three basic judicial discretions. They only apply in criminal cases. Please don't give me an assignment or an experiential essay or an exam question where you apply those judicial discretions in civil cases, because it will hurt me as much as it hurts you when I have to give you a very poor grade for answering that question. These are criminal cases only.